Thank you so much for joining Conversations with Cohen. I'm your host, Greg Cohen, office leasing specialist at Cressa. And this podcast and video is for office tenants to help educate them about all things regarding their office space, from leasing to architecture and everything in between. Whether you're an entrepreneur thinking about your first office or a director of real estate managing a large real estate portfolio, this podcast is for you. I've got a really interesting show for you today. My guest is Larry Hutcher, a founder and managing partner of Davidoff, Hutcher, and Citron. We're going to be talking about what you can do if your business has been a victim of COVID and you can't meet your lease obligations. An unfortunate reality of the coronavirus is that many businesses have seen a material impact to their own bottom lines, which has affected their ability to pay their rent. There are a lot of tenants that just don't know what to do. So I thought best to have an expert on someone who can shed some light on what can be done. By the way, if you want to reach me, I'm at Greg Cohen NYC on Instagram. And if you're new to this video series or podcast, hit the subscribe button below so you don't miss any future episodes. Today, I'm very excited to be joined by Larry. If you don't know him, he's built his career focused on commercial law and litigation. He has significant experience in real estate litigation representing tenants in lease disputes as well as development issues. He's been published in the Times, the Post, the Wall Street Journal, as well as numerous real estate publications, including Real Estate Weekly. As I'm sure folks know by now, I'm a huge believer in hiring a dedicated office leasing attorney when preparing to sign a lease, because it is incredibly nuanced subject matter that requires an expert. And I maintain it is money extremely well spent to ensure maximum flexibility and protection. But even the best of preparation, things can go wrong, which is why we're speaking to Larry today. Larry, welcome to the show.
Thank you for having me.
I'm very appreciative of your time today because I'm getting tons of questions from tenants about how to get out of their existing lease obligations. They're preparing for the worst, hoping for the best, but trying to understand what their options are. These are travel-related businesses, theater production companies, Pilates studios, chiropractors, and the list goes on. So perhaps we can start with, if you own a business and you're concerned about making rent, what's the first thing to do?
So it's very hard, and I want people to understand that there are general guidelines that govern this, but more often than not, it may rely specifically on the terms of a lease that was negotiated. And it's interesting that you referenced the need to hire a sophisticated landlord-tenant lawyer in terms of making sure that the lease was properly negotiated. What we are finding now, I am not that person. I am a litigator. I deal with the facts as they're presented to me after the lease has been signed, after the proverbial stuff has hit the fan. And more often than not, it becomes apparent that the lawyers never envisioned or thought about the circumstances that we're not facing. While there might be general terms in a lease, no one 2, 3, 4, or 10 years ago envisioned pandemics, or if they did, it was highly unusual. So the majority of the leases that we have seen do not address these circumstances. So while I can speak in generalities, I don't want someone to take the position that I'm giving them actual legal advice without actually having seen a specific lease or talking about the specific facts. So with that general caveat, I can tell you that the situation that tenants face today is unique. And obviously we need to draw a distinction between commercial tenants and retail tenants. The typical business tenant is in a far less desirable position than a retail tenant, or we have clients that are dealing with dormitories where the governor, and particularly in New York, has issued executive orders closing those down, where the governor has issued orders closing retail space. Those businesses are in a far better position to argue frustration of purpose, impossibility of performance, and therefore can either argue that the lease should be terminated or the rent should be waived. So that is a very different situation where you have a commercial tenant, a regular office, for example, an accountant or a lawyer who is in an office building where the office building has remained open. It has been available. They could have used it. The landlord has said, I've made precautions. I've installed thermometers. I've disinfected. The space is ready, able for you to use. If you don't want to use it, that was your decision. But even in those circumstances, I have advised tenants to actually always reach out to the landlords, make your pitch. If a landlord would not want to have a client or a tenant face bankruptcy, have to relet the space as opposed to continuing to work with them. So I would advise every single tenant at this time that they should, if not withhold rent, enter into discussions with their landlord. I have found that if a landlord is not willing to actually waive rent, almost every one of them will agree to some type of deferment payment program. No one should be put in a position where their existence is put at risk by reason of rent obligations.
Now, that brings up two questions. One, deferment and abatement, that's kind of just kicking the can down the road, right? Because at the end of the day, the landlord might say, you know what, give me another year and I'll give you a month free, or you have to pay, I'll give you a couple of months that you don't have to pay, but you have to pay them at the back end of the lease. And that doesn't really necessarily do any good to a business that's on the decline. Okay, so first question is, what can tenants do with regards to their security deposit and how that could play a role in helping in this in helping resolve this?
Well, typically tenants have very little rights vis-a-vis security, because once it's being held by the landlord, it's really the landlord's choice as to what to do. And landlords have been very aggressive in saying, look, I'm going to take this and I will deal with the issues later on. All the tenant can do in this circumstance is say, look, please don't take it. I'm not in an adversarial situation. But once again, that simply comes down to a one-on-one negotiation with the landlord. So typically landlords, I represented a landlord, a well-known landlord on 3rd Avenue, and he used to have a sign in his office. Remember, I am the lord and landlord, and you are the ant and tenant. And once they have your security deposit, he is the lord, and he can make the determination as to what to do with it. So once again, it's communication. You need to talk. Once the security is taken, obviously a tenant is in an adverse position, but there's really very little they can do to stop a landlord from taking that.
So then let's
regrettably.
Just say, we keep on hearing this term workouts. So let's just say deferments and abatements, that just won't work, right? What next? How do you get involved? What do you do in this process?
Well, let's talk about on a retail side. And I've been involved on this on many sides. We simply advise the client to stop paying rent. We have commenced actions in Supreme Court, New York, asking for declaratory judgment that the leases have been terminated, that there is no obligation to pay rent due to the existence and creation of executive orders by the governor, that was an actual frustration of purpose of the lease, and we are entitled to a declaratory judgment that we have no further obligations under the lease, and we're entitled to our security back. So the only way to get the upper hand is to make sure that you get to Supreme Court seeking declaratory judgment before the tenant goes into landlord-tenant court, where there is no ability to raise these counterclaims. So the first thing I advise that every single tenant in this situation, do not wait for the landlord to commence an action in landlord-tenant court. That is simply the worst position to be in, because they can wind up with a judgment there, and all of the tenant's claims are relegated to an independent action in Supreme Court. And that would be after the landlord has already entered a judgment. So that's not the position you want to be in. You need to be aggressive in this situation and not sit back and hope things are going to get better.
And what if you are an office tenant in a
office? Yeah, the office tenant, it becomes a little more difficult. For example, we are dealing with an office tenant that has an inability to use the space because their business has been directed that they can't operate. So that is an argument that we could say that is a frustration of purpose, because it was clearly intended that the office space used for this purpose can no longer be accomplished. But if you're an accountant, an architect, or an advertising agency, and you're continuing to work and your people are continuing to use the space, you're in a very difficult argument. You're not going to be able to maintain the arguments of impossibility of performance or frustration of purpose. So there isn't a lot of good news for those people, other than to use the economic arguments that because their business has been so dramatically impaired, I have no choice but to seek your help. I would not recommend commercial office tenants unless there's specific clauses in a lease that would give us the ability to raise an argument to commence an action. Unlike my restaurant clients or those in other businesses.
Have you seen any clauses in any leases that have helped office tenants that they've been able to use?
Yes, absolutely. Where there's talking about arguments where there's been a taking or there has been an inability to perform. We've had 2 or 3 of those where there were helpful clauses, and we've advised them to pursue other remedies. Absolutely. It all depends upon the specific terms of the lease.
Now, I keep on hearing, Greg, I have a personal guarantee.
Correct.
So I'd like to talk a little bit about, one, what a personal guarantee is for people who don't know. 2, why they had to sign a personal guarantee. And 3, what they could and what the remedies are to get out of that obligation.
So it's really important that obviously a guarantee is a legal obligation that an individual assumes for the debt of either another individual or corporation or an LLC or some other entity. It basically is saying that if you, the principal obligor under this lease or obligation, defaults, I will answer for that. Many leases contain what is not a typical guarantee, but is called a good guy guarantee, and which is a very different thing than a typical guarantee or an unlimited guarantee. An unlimited guarantee says under any circumstances, if the primary obligor does not answer for his debt, I will take care of it. A good guy guarantee says, look, we recognize that the entity, the business, the architectural firm is on the hook. But if that entity surrenders its space, broom clean, and at the time it surrenders, there is no default, that is, all rent is timely and all other obligations are fulfilled, if you, Mr. Principal of that company, surrender the lease and walk away, I will not seek to personally charge you with individual liability. The corporation or the architectural firm or the LLC, they will stay liable. They don't give up liability against the entity, but they say you individual, if you subscribe to that philosophy or you make sure they comply, I will not come after you individually. That's called a good guy guarantee, and it's designed to prevent companies without assets from holding over and thereby preventing the landlord from either relenting the space or recovering the space and suing an entity that has zero money. Now, what's interesting here is, and I just want to give a classic advice, a lot of lawyers don't understand exactly how the good guy guarantee works, and they'll tell a client, have the landlord apply the security deposit for the 2 months that are owed and walk away. The law is very clear. You cannot do that. You have to cure any defaults that exist, and the landlord is not required to use the security for that purpose. So that's just an important fact that a lot of people miss, and some people say, look, you'll apply the security deposit, they walk away, I have no personal liability. and a year later the landlord comes in and says, no, I didn't re-let the space and you're personally liable for a year. So you need to be very mindful of that. But the second thing is, New York City Council passed a law that said individual guarantees that are seeking to be enforced by landlords due to the default from COVID are now unenforceable. Now, the interesting thing is that law has already been challenged in court. So we don't know whether a court will ultimately declare that unconstitutional. So I've been in the very difficult situation of having to advise clients as to whether that surrender of a lease, not in default or otherwise now, because that would say you don't need to cure the default because your guarantee is null and void, will that ultimately be held effective by a judge? No one knows that. And no one knows what the impact is if it's declared unconstitutional, whether a landlord can come back and say, now you're personally liable. So all of these things are fraught with peril. But my best advice would be to somebody that is walking away from a lease, cure the default so that you're certain that there's no individual guarantee liability under a good guy guarantee. And that way you know for certain that if you have assets that you wish to protect, that you're not going to be hit later on.
So two things. One, I've heard which I think is sage advice, that if you don't have to sign the good guy guarantee, don't. And the way to prevent that is by putting up more security up front. So if you have the opportunity to do that, that's one thing that you really should think about. So I think that makes a lot of sense. As far as the personal guarantee, what are ways to avoid what are ways to avoid a personal guarantee going forward for tenants? And are there ways to separate yourself once you've already signed a personal guarantee?
So, the classic definition is, what a guarantor is, and it's a fool with a pen. That's the classic definition of a guarantor. So once a guarantee is signed, there's really very little that anybody can do to get out of it, other than to, at that point going forward, provide additional security or some other incentive to either the landlord or the secured party to say, let me go. So obviously the best advice is do not sign a guarantee. If you have signed it and there's an ability either on an extension or otherwise to say to the landlord or whoever the obligor is, I'm willing to give you an additional year, but I want the guarantee released, or you cap it at a certain amount, whether it's 2 months, 3 months, I will not be liable for X. And no matter what, it's a good guy guarantee that if I do surrender the space in a timely manner, I will not have individual liability. So I think that's the best way to deal with that.
Great. So, at some point, there's an amount of money that, let's say you have a year left on your lease or a year and a half left on your lease, there must be a threshold at which it costs the landlord more money to sue for the remaining obligation than to let the tenant off, out. So what does it cost for a landlord, for some perspective, to sue a tenant? And is there a period of time that it's just not worth, or an amount of money that's just not worth for a landlord to go after a tenant?
Well, typically most, I would say 99% of every commercial lease I have seen contains a legal fee provision that says in the event of litigation and the landlord is successful, he will recover the fees. So typically, that is not the determining factor as to whether a landlord will pursue. The real issue tends to be the economic health of the tenant. I have seen landlords go after tenant for 1 month, 2 months worth of rent because they feel that it's entitled if they think it's recoverable. Typically, if I were advising a client as to whether or not to pursue an action, the first thing I always say is, we can get a judgment, but what are you going to do with it? A judgment isn't worth the paper on which it's written unless it's enforceable. So it typically comes down to, is the entity going to have any ability to satisfy a judgment, assuming we get one? If the answer is yes, then 9 out of 10 landlords will pursue that, regardless of the fact that it might be insignificant. To a small landlord, $100,000 is a lot. To a REIT, it may not be. So that's going to be an individual determination. But I don't think there's any one particular number. But once again, I don't think that's the motivating factor. I think it's the collectability is whether it is.
Okay. So I like to talk about lease hacks and tricks that tenants can use when they're thinking about their next lease. So advice for a first-time tenant when negotiating a lease, so we can avoid as much as possible about this current situation. More specifically, things that you have seen in these leases as you've gone through them in the last few months, as you're trying to help, that you say, I can't believe somebody actually signed this thing.
Well, we have seen situations where in the event that there is clauses where tenants have signed, where there's an inability to use the space, where a tenant is still required to pay rent and assert those as a separate claim. So you never want to be put in a situation where if you can't use the space, whether it's for a condemnation or a hurricane or a flood, that you're required to continue to pay and only have to assert those defenses in a plenary action against the landlord. So that's the single most important thing. If there is particularly those even include due to the landlords. Let's say there's a flood in the building, you continue to have to pay when you can't use the space. Come on, you got to be able to negotiate better than that, or there should be at least an abatement during that period. So that would be the single most important thing that I would direct any tenant to make sure going forward, that if indeed there is an inability to use the premises, that there is some type of abatement and they're not required to commence a separate action.
Okay, that's great. As you think about the situations that you're currently working on, could you help shed a little light about what you think the most common questions are that you're getting from your clients that might be on listeners' and viewers' minds that they don't know who to ask, right? If they don't know who to ask.
Sure. The typical question that I get, and the most important one, is, should I pay the rent while these negotiations are going forward, or while these are going forward? And my typical answer is no. Because if the landlord is collecting the rent, he has really not the greatest motivation to work with you. But that is in a vacuum. If you have a good relationship with your landlord and it's long existing, and it's a family-owned real estate company, sometimes I say you may be better off paying because you want to stay in the space. It's a question of negotiating something that you could live with. So there can't be any specific one pat answer. It all depends upon the particular fact and circumstances, and that's what makes my job fun. I look at the leases. I see you're there 10 years. You got another 20 years. You're happy. You just put in an installation. You're going to stay there. Is the business healthy? Are you going to need just 6 months to work this out? How do we deal with it? Are you now a retail restaurant? That you haven't been able to open for 4 months. You can't afford to pay the rent. You're not going to be able to pay the rent for the next 4 months. Hey, landlord, here's your space. Go out and try to find a new restaurant client in this time period. I want a complete abatement. I'm not going to pay a dime. I'm not going to pay anything until I'm open for 4 months. And I'm not, you want the space back? Here it is. I'm taking my name. I'm taking all of my, because I always advise my restaurant clients, put your name, all of your IP in a separate entity that's not part of this company. So God forbid something happens with the lease, you can take your name and move across the street with it. You enter into a license agreement with the entity that's on the lease that says, they're using XYZ name at your consent. But if something happens, you lose it, you can go across the street. There'll be lots more defaults. So that's a situation I see regularly.
Okay. And when do you advise folks reach out to you, Larry? You know, how early in the game?
Now, in this situation, I take calls every day. Sometimes I say I can't help you. I'll look at a lease and say, there's really not much I could do. Other times I find clauses that are helpful. Obviously, there needs to be a reckoning. The sooner the better that I can get involved, the more ability I have to help.
And no episode of Greg C TV would be complete without talking a little bit about food. So my question is, when you settle a case or you win a case and you go out for a celebratory meal, is there one place that you always go to, or the place that you look forward to going to for a meal, for a celebratory meal?
So I am fortunate enough to represent a number of great restaurants in New York that are really good clients. Among them, Campagnola for great Italian food on 73rd and 1st. So that if I want to go, I'm fortunate enough to represent La Grenouille. If I want a great French meal, I love to go to restaurants where they know me because I am Philippe Masson, who owns Grenouille, typically has a 2.5-3 hour meal. He feeds me in an hour. I like to go to places where people know me, but those are great restaurants. My best friend owns Sardi's in Times Square, so anytime I go to the theater, I'm able to go. Know that I'm going to get a great meal there. New York, one of the truly disappointing things now is that all of these great restaurants are closed, and it's difficult to really enjoy the benefits in New York. But I'm a huge foodie too, so it's one of the things that we hope will get back to normal ASAP.
And Larry, one of the favorite things that I love to do, so I do a segment called "What's for Lunch," because one of those questions that tenants ask is every day when they're in their office is, hey folks, what are we having for lunch, right? So
right.
I'm looking forward as well to going back into featuring a lot of these restaurants. They need our help more than ever right now.
Totally true.
They are the lifeblood of New York City, and they need our support.
Right. Hey, I'm there. I'm spending money. I go out to eat. I eat out lunch and dinner every day. So I'm a big supporter.
Well, I would love to break bread with you at Campagnola. I've actually never been there, so when we're back in New York City and we're humming, I'd love to do that.
I look forward to it. It's been a pleasure talking to you.
I really want to thank you for your time.
I hope this was helpful.
This was extremely helpful. For folks, I'm going to put in the show notes Larry's firm's contact details as well as Larry's details. This was Conversations with Cohen with Larry Hutcher, and we look forward to seeing you next time. Thanks so much.
Be well, everyone. Stay healthy. Stay safe. Thank you.